SJC-12068, Commonwealth v. Calvin Horne.
Good morning, Ms. Jacobstein.
Good morning, Your Honors. Rebecca Jacobstein for Calvin Horne. Profiling evidence is inadmissible, and in this case, the Commonwealth presented evidence of the stereotypical physical and economic characteristics of a crack cocaine addict to prove that Mr. Horne, who did not share those characteristics, was a crack dealer. And this type of reverse or negative profiling evidence is also inadmissible. And they're both inadmissible because profiling evidence at its core is fundamentally irrelevant. It is irrelevant because a profile is no more than an expert's opinion that a person who commits, or that people who commit a particular crime exhibit shared common characteristics. But these characteristics, which are common to others, have no place in a trial, which is an individualized adjudication. The fact that some people, or most people who commit a crime, exhibit a certain characteristic doesn't have any relation to whether another person has committed that same crime.
How's this issue been handled across the country?
I have no idea. I would hope that it's been handled exactly as I'm asking today, because
Good,
stereotypes really have no place in our courts, and that's what we're doing here.
Now, what do we do with I gather here you claim that there was a failure of notice, which was objected to, but no objection made to the admission of the profile testimony.
Right. The way the objection came about was the expert testified to the physical characteristics, and defense counsel said, respectfully, this is getting a little wonky, for lack of a better term, and what people look like, but they are addicted to crack. So she did not bring specifically the profile. She objected to it.
So that's going to really matter. Wonky, and there's no foundation, I think. And
there's no notice, right?
right. And this profile evidence was only part of the expert testimony. There was a lot of other expert testimony that you see all the time with street-level drug distribution that was noticed as well. So is the standard that we're looking at here for the unpreserved error going to matter in this case?
It doesn't matter in this case because there was prejudice and it materially affected the verdict. And then there's the fourth prong, which is failure to object was a tactical decision, but she did object, so on different grounds, but so that clearly would not have come into play here. The reason it was prejudicial in this case, beyond the fact that profiling evidence is inherently prejudicial, this court has so found, is that it was a live issue. Defense counsel asked for an instruction for possession. She argued lack of intent in her closing, and then the judge instructed on straight possession.
But the defense was it wasn't his drugs.
That was one of his defenses, but this is not an inconsistent defense.
It was in the street, and it's not my drugs, and they were individually packaged.
She argued those things, but what she also argued is there is no evidence that Mr. Horne was distributing drugs that night. Now, again, she asked for the lesser included instruction, and this court has held that in another case, that it is reasonable to emphasize one argument and leave to the jury another argument, and leave to the judge the discussion of law on that argument. And that is Commonwealth versus Stockwell, which is 426 Massachusetts 17. So the fact that she didn't argue it doesn't mean it wasn't there for them, and doesn't mean it wasn't a live issue. And I think she did argue it. It was just kind of all encompassed in a grand issue.
Now, help me to understand. I don't know that I've seen a case where there's the interaction of the purported failure of notice with regard to a matter and then the failure to object to that. I mean, I understand if the Commonwealth had said we plan to offer profile evidence, then defense counsel could arguably have done some research and said, oh, you can't admit profile evidence, and here are the appeals court cases which say it's not in. Without that notice, defense counsel may not have had an encyclopedic knowledge of the law, and you've got a judge who says everybody knows that, it comes in. What do we do with the interaction between the failure of notice and the failure to object?
Well, it's not, it's a failure to object on terms. It's not failure to, she also failed to object on foundation grounds, which is, again, not the same as what I'm arguing today, but kind of brings us to the same place, which is, I didn't know this was coming, and this is weird. It shouldn't be coming. And this guy can't testify to this because, and she didn't explain explicitly why, beyond that he wasn't an expert, but I think in the grander scheme, you can say, well, you can't be an expert in this. But, so I guess that's the interplay, is that it was there but not expressed.
So does that have any impact on what you think it is, what the standard of review is?
I have conceded a substantial
You
risk
say
standard.
substantial risk, yeah.
But I'd be glad to go with prejudicial error.
Really?
But I think this materially influenced the verdict, which is the next prong. And the reason it materially influenced the verdict is because the Commonwealth argued it. When they got to their argument to say, hey, how do we know he was a drug addict? What they said was, how do you know Mr. Horne possessed it with the intent to distribute it? Does he look like a drug addict? You saw the pictures of him. Drug addicts, particularly crack cocaine addicts, are skinny, they are thin, they have rotted teeth, they are drawn out. And they go into how he's a big man. And then after this, that's when they say, and also, he has multiple cell phones and that stuff. But as I stated in my brief, there's evidence, and it would be sufficient. But that's not what they relied on. And
Well, they could have relied on the 26 different packages.
they could have.
Yeah.
And then we wouldn't have a question as to whether or not this materially impacted the verdict. If they
But
hadn't
how do
argued
we
it,
know? How do we know what they relied on?
well, I think that we can conclude that they relied on what the Commonwealth asked them to rely on.
Why? You may give more power to the prosecutor's closing argument than perhaps it warrants.
I think this court has held that there's no reason to think the evidence didn't have the intended impact that the prosecution offered it for. But I also think that between the fact that this was offered as actual proof and the judge's acknowledgement that the jurors probably think it anyway, I think that it really had I think it really probably had an impact on the verdict.
How about all the testimony about how unlikely it is to have 26 packages, the 5s and the 10s? I mean, I don't disagree with, this is what the drug dealer looks like, and he's got yellow teeth, and he's a mess, and you've got this big, huge, strong, athletic guy who's holding off all these people. That was inappropriate evidence. I understand your position on that. Let's just assume accept it. For substantial risk, this was really not even alternative grounds. It was a throwaway, oh, well, I'm requesting a lesser included, but the thrust of the closing was, not my drugs.
The thrust of the closing was, it's not my drugs. But again, this was brought to their attention, and she does mention the fact that we don't know that these cell phones are his, but they weren't ringing. We don't know who they were calling. They didn't link them to him. And so she did go into other factors that one would consider if one were going to only consider valid factors as to whether or not he was possessing it with the intent to distribute. So yes, there were 26 bags there, and that is certainly a factor that weighs against Mr. Horne. But that's all they have. And so is that proof beyond a reasonable doubt to them?
Well, it's not all they have. I thought there was some testimony from the expert, unobjected to, and arguably within the notice, that the officer who testified, who was not a precipient witness, they did that right, had never seen ever somebody with this many packages, or even close.
Oh, well, what he said was that he doesn't charge people who have more than 5 packages with possession with just straight possession. He charges them with possession with intent. So I think that goes to the fact that he gets to draw a line in the sand, and that's where he draws it. And so the jury could accept that. The jury could accept, well, he gets to decide, and this is where he decided to draw the line, and he probably has a reason for it. But that in and of itself, I mean, again, that it goes to weight, but that's not what when the prosecution argued this, they argued he doesn't look like a drug addict.
Right,
He
but
must be a drug dealer.
I honestly didn't understand that. I thought that the police officer had testified that he didn't usually see drug users with this many drugs, not that he made a charging decision, because that would be pure
No, not in this
unadulterated
case.
vouching.
Yeah, certainly he didn't make a.
But in the testimony, did he testify? Well, if I see them with more than 5, I charge possession?
That's what I thought he said, and now
Okay.
I'm questioning that, so I'll have to
Is there
look.
an objection?
No,
Okay, thank you.
thank you, Your Honor.
Mr. Florence?
Good morning, Your Honors. May it please the court, Justin Florence on behalf of the amici who filed a brief in this case, and thank you, Your Honors, for soliciting amicus briefs and for allowing us to participate in argument. The profile of the purported physical appearance characteristics of a drug user that the Commonwealth introduced here is not relevant, is prejudicial, and I think illustrates the flaws with this type of profiling evidence that's led this court to hold them impermissible. To begin, trained substance use experts, psychiatrists, doctors, and others don't look at all to physical appearance characteristics to identify whether somebody has a crack cocaine disorder. Instead, they look at behavioral factors, things like recurrent use, built-up tolerance, or whether the drug interferes with occupational or social behaviors. And they don't make that type of diagnosis of a crack cocaine disorder on the spot just by looking at somebody. Instead, experts engage in a sustained interaction to really communicate with a person and learn about them. And to the extent that there are kind of observable physiological characteristics at all associated with crack cocaine use, they're not the ones that were in the profile here, but instead things like muscle twitches, tremors, or dilated pupils. And I think that just shows how over and under inclusive the profile that the Commonwealth introduced here was, and why these profiles are inherently that way. It's over-inclusive for the obvious reason that there are all kinds of people who are thin and have bad teeth and yet are not crack cocaine users. And it's under-inclusive because it misses the full portrait of what drug users and crack cocaine users in this country look like. They come from all walks of life. It includes people who are star athletes who are in outstanding physical shape, people in demanding white-collar professions who have excellent teeth. And a huge flaw in the profile is the way that it conflates crack cocaine users with crack addicts, to use the term that was used in the trial court. And critically, as we lay out in our brief, most people who use crack cocaine do not develop an addiction. We cite a statistic that only something like 5 or 6% of people who use crack cocaine develop an addiction within 2 years. And so the way the Commonwealth sought to use the profile here ignores that there are many people who may possess crack cocaine, even large amounts of crack cocaine, but who do not have an addiction, who might not meet the addict profile and yet don't intend to distribute. And just to pause on the term crack addict that was used in the trial here, that term itself kind of highlights the prejudice that this type of evidence can have. Professionals in the field, and this is something that our clients have felt very strongly about, no longer even use that term crack addict because of the kind of prejudicial stereotypes and stigmas that are associated with it. And instead, the field uses the term substance use disorder. And even the White House drug czar recently, just this week, published an article on why terms like crack addict can have just a inflammatory, prejudicial effect that keeps people from getting the treatment they need and plays on these stereotypes. And I think that and the way that this evidence was introduced and used here goes to the deeply prejudicial component of this type of evidence. Here we have a case where the prosecutor explicitly elicited this type of appearance profile testimony, asked the witness multiple times, can you tell me about the physical appearance characteristics? The trial judge, as one of your honors noted, accepted it as common knowledge that to use the term crack addicts are going to exhibit certain physical signs.
Well, I don't understand why that's kind of contradictory. If the judge thought it was common knowledge, why did she think expert testimony would be appropriate?
I agree there is a contradiction there, and I think what's really happening here is that the expert is being used to sort of validate what's really just a stereotype that's out there in the world and to give it some sort of imprimatur of legitimacy or truth in a way that then allowed the prosecution in the closing to draw on that and say, you know, as my sister said, how do you know he's committed this crime? What's the substantive evidence of guilt? Does he look at him, compare him to this profile, not that you may just know from the media, but that an expert testified to, compare him to this profile and convict him on that basis? So for these reasons, we think this case is an important opportunity for this court to remind the trial judges and others on the front lines of these cases that this type of profile testimony is harmful, is prejudicial, has no basis, and shouldn't be in the courts of the Commonwealth. Thank you, Your Honors.
Thank you. Ms. Anderson, good morning.
Good morning, Your Honors. May it please the Court, Teresa Anderson on behalf of the Commonwealth. We're asking this Court to affirm the defendant's convictions. I'd first like to take a step back and look at the framework for evaluating this type of evidence. I think we all agree that we have long-standing permissible evidence and opinion testimony that an expert can testify this physical evidence is consistent with drug distribution.
Do you have any idea about any other cases from around the states on this negative stereotype in evidence?
I don't, Your Honor, and I guess that would fall to the other end of the spectrum. I would agree, and I think the courts around the country would say, profile evidence and stereotypes have no business and no place in our courts of law. So I think that's the spectrum that we have. We have, on one hand, experts that can look at physical evidence, baggies, scales, paraphernalia, packaging, money, all of that type of physical evidence and draw an opinion. This is consistent with or this is not consistent with.
Wasn't the expert basically saying he doesn't look like a crack addict, so therefore he's not a crack addict?
No, I don't think so. And that's, again, on the other end of the spectrum of impermissible profile evidence is criminal looks like this.
Isn't that the way the prosecutor argued it?
Yeah, because he says,
referring to the expert?
he said a crack addict has these particular physical attributes, and then
Yellow
he says,
teeth.
but look at this guy. He's a big, healthy, virile guy, so therefore it's not personal use.
Yes, and then goes on to, he possessed it with the intent to distribute, look at this evidence. There is one line in this closing argument I wish wasn't there. Quite frankly, he's not a drug addict, he possessed it with the intent to distribute it. And I don't think it was necessary, and so in this case, there is no substantial risk of a miscarriage of justice.
Beyond substantial risk, the question I think we have for you as well is whether or not this testimony is permissible at all.
And that's where I think it fits into this framework. It's not the physical evidence and the description. It's not a criminal looks like this, he looks like that, therefore he's a criminal. It fits somewhere in the middle, and it's those.
Isn't it just the mirror image of the latter? He doesn't, an addict looks like this, he doesn't look like that, therefore he's not an addict, therefore no personal use.
Because I think that is permissible. It's the therefore no personal use, therefore you have to be one or the other. You have to use it personally or intent to distribute. I think that's the ultimate issue that we're going for here. We're looking for how do we prove intent to distribute. And one way to prove intent to distribute, one among many, is the lack of possession for personal use.
But you can't even get there unless there's some evidence that he's an addict. There's a lot of people who use substances who aren't addicts.
I agree, and I think that's why in that middle category of evidence where you have the actions of people and you have the physical characteristics. So I think where you have he's not hanging out on a corner, there are certain attributes and there are certain modus operandi for addicts and for drug dealers. And I think in that testimony, Robinson, Dennis, are both cases where you can use an expert to give you that kind of characteristic profile evidence. It's based on
That's behavior.
actions.
That's behavior, though, right?
Absolutely.
You were saying the same thing.
Absolutely. And then I think you go one step further and you go, behavior, what does that manifest physically? And so you do have, when you have
Look, in a child sex abuse case, you couldn't have a police officer come in and say, child sex abusers look like A, B, and C. Look at this guy.
absolutely not correct.
Not right.
I think that
This is the mirror image of that, though, right?
it is. I think the characterization of negative profiling evidence is accurate, and I don't think that there's currently any restriction on that evidence
Okay,
in the
now-
Commonwealth.
and now I'm confused. Are you saying that you can do this again?
Yes,
Really?
I am.
Why?
Why?
Because the rule is you cannot introduce a profile to prove that the defendant is a criminal.
But you admit it's the mirror image.
Exactly.
So-
Because there is no restriction.
So we're being very literal
Yes.
here?
I don't think the mirror image is ruled out. Maybe this case will decide that, but there is no case where the profile of he is not this, and again, it's not one or the other. He's not either an addict or a drug dealer.
You always start an evidence issue with relevance. Just put aside all these concerns about profiling for a minute, although they're very serious concerns. So you have the expert on the witness stand describing, what the drug addict looks like. We've got no foundation that he's a drug addict. In all the years that I did the drug court, I never saw a defendant in the drug court that looked the way that we got this description. So, put aside profile, and how do we get to relevance?
I think the foundation was met based on the officer's training and experience, based on what he's seen in his career. I think it was cut back during cross-examination. I think that a lot of that evidence, which the defense counsel was also going to use the profile of drug dealer. I guess to take it one step further, her closing argument is not just he didn't possess these drugs, but it's whomever possessed these drugs was a drug dealer, and look at my client, he doesn't have the characteristics of a drug dealer.
So if you have a case in which the person has bad teeth and is skinny, and you're claiming he possesses with intent, and the defense offers an expert to say, look at this guy, he's skinny, he's thin, he's skinny, he's got bad teeth, he looks just like a drug addict, therefore you should find that he's merely possessing, you say that's okay.
No, I don't think that using...
Well, how can it be okay for you and not be okay, how could it be okay for you to prove possession with intent, but not be okay for them to defend against that with the same evidence?
Because I think in your hypothetical, Your Honor, you're getting at possession. I don't think that you can say he looks like a drug addict, therefore he possessed drugs. I think you can say...
No, I'm offering to say this guy is a drug addict and therefore not a drug dealer.
Right.
So
His defense is,
the
I
defense would
possess them
be,
for my personal use.
I have a lot of drugs on my person, yeah, because he looks just like a drug addict. This is what drug addicts look like. Therefore, you should find that the Commonwealth has failed to prove that he's a drug dealer, because you can find, because if he has bad teeth, that he's probably a drug addict.
And
you say, no objection, Your Honor.
correct, and that exact...
You think that comes in?
And that exact hypothetical and fact pattern played out in Commonwealth versus Hamilton. It is 83 Mass Appeals Court 406, a 2013 case. And it does come in. In that case, there was no objection. Some of the evidence was in response to defense counsel's questions, but the court found it was relevant to intent to distribute and the defense of lack of possession.
So you're saying it works both ways, in other words?
Yes, I think it
So I
does.
misunderstood you before. I thought you said it was not okay for the defense to put it in.
That's because that's what she said.
He didn't really mean it.
Right.
But
so-
apparently
Maybe
you
I'm
didn't-
confused, I
apparently-
apologize.
Well, let me ask you a substantial likelihood
Sure.
issue. Considering all the evidence in this case, the jury just may well not have bought that the drugs just ended up in the middle of the street. And so does the closing matter then? Because it's all about look at this big, huge guy that took 6 of us to get control over. He's not a drug addict. And the defense was a pretty tough sell. So why wouldn't it satisfy substantial likelihood?
I would disagree that defense was a tough sell. It was consistent. The defense for the firearms, which he was acquitted of, were not my car, not my trunk, not my guns.
Right.
Similarly here, not my drugs, middle of the street. And again, where the defense counsel also used this sort of profile evidence to say, these drugs, how they're packaged for just, she doesn't say this literally, but look at these drugs, look at what a drug dealer, you've heard about what a drug dealer can do, has phones, has the money, et cetera. These phones are sitting in the car and not ringing off the hook. Therefore, he is not a drug dealer. Therefore, he did not possess the drugs in the middle of the
I
street.
understand, that's a fair point, but I'm talking about the impact, not my firearms, I think it was somebody else who was in jail who owned it, and somebody else who was driving it at one point. This is the street where he just was, where they find the drugs.
I do agree that there's strong evidence that his boot came off and that these drugs stored in a boot, again, a behavioral type characteristic of a drug dealer, belong to the defendant.
Does that make the closing a lot more important about the disparity in how the drug addict looks and how this defendant looks?
I don't believe so. I think the closing argument, again, when read in context and taken as a whole, there's one sentence I would love to take out. But it is supported by the evidence, and it is then continued with, he has cell phones, he's running around with 26 rocks, and then this is the most that he's seen with someone that's an addict is 5 rocks. Again, behavioral, I think that's perfectly appropriate. So to the extent that the physical characteristics and this negative profile, again, based on a description, is improper, which I don't concede that it is, in this case, there's no substantial risk of a miscarriage of justice.
May I ask you, our cases have pointed away from using this kind of evidence, and I'm just wondering, I mean, lots of appeals court decisions saying you can't do this. Why is it that the Commonwealth consistently tries to use this kind of evidence? I mean, you can prove it by other ways. It's obviously prejudicial, and I just have a hard time understanding why this keeps coming up.
I agree. I think there's a line in, it's either Johnson or Jackson from this court. It's an admonition.
Danner, Getson-Danner. I mean,
Right.
every time we say, okay, you can't do it, but it's all right because the evidence was substantial in other ways.
Right.
And it just doesn't seem to be changing the way prosecutors do business with us saying it's bad, but it's okay.
Right. No, and I agree. And I agree that this is not terribly probative evidence, that because someone looks thin, therefore they must be a addict or user or anything. I mean, that, again, that somebody fits a stereotype is not evidence that they are something, whatever that is. So I don't find it to be particularly compelling, in my personal opinion. I'd be happy to share that with others.
Might resonate with a jury, though.
I don't know that it does, and I don't know that it doesn't. And again, like Judge Giles said, to the extent some of this is in the personal knowledge and the...
Yeah, but then you hear that, in fact, that's wrong, personal knowledge, right? I mean, it's...
Which I think is also common knowledge. I think that you say, you know, someone with rotted teeth doesn't necessarily mean that they are addicted to a substance. That could be any number of other reasons.
In terms of Justice Hines' comment, what do we do with the fact that there was no notice given of your intent to offer profile evidence?
First,
It said he'll testify regarding common practices and activities of street-level drug dealers. That's, of course, fine. The appearance, packing, and value of street narcotics, that, of course, is fine. The vernacular of illegal narcotics users and dealers, that, of course, is fine. But there was no reference to and the profile of crack users or addicts, which would inform defense counsel that that may not be fine, and perhaps I need to do some research to find the cases Justice Hines has noted, and perhaps then I should object, and then, of course, they don't have notice of this, and therefore there's no objection, and now you say there's no objection, so it's a substantial miscarriage, a substantial risk. It's troubling that, I mean, you put defense, not you, your colleague put defense counsel in the position of having to think on her feet, perhaps not well enough, but if there had been notice, that would have given the opportunity to have done some research, find the cases Justice Hines mentions, do motion eliminate, say, Your Honor, this should not come in.
Well, I think there is notice because here you have an expert and what his ultimate opinion and what ultimately his testimony is this drug evidence is consistent with drug distribution. I think that's the bottom line. I think certainly notice was given on that
Right,
grounds.
I mean, I agree that all the stuff that was given is fine. I mean, it's only this extra part that is not, perhaps not fine, but there's no notice given to defense counsel to say, you know, you may want to take a look at the case law regarding this.
And I would disagree. I think it falls into the category of the expert will testify about street-level narcotics activity, and then again offer his opinion that it is consistent with distribution and inconsistent with personal use. We certainly allow that type of opinion testimony also, not just it is consistent with distribution, but it is inconsistent with personal use. And I think where the focus can stay on the evidence, the focus can stay on the behavioral aspects, to the extent it sometimes gets into the physical characteristics. This case that the appeals court referenced, Commonwealth versus Carbello, in the Horne decision here, I think is also directly on point, where there is some leeway to get into physical characteristics, but no, I absolutely agree that where you start offering testimony that so-and-so looks like a criminal, therefore this defendant is a criminal, that is improper.
Okay, thank you, and we'll take our morning break. I think just 5 minutes.